Good morning. I'm Pamela Jo Hatley. I'll be serving as the Land Use Hearing Officer this morning. If you can all stand, please, and we'll say the Pledge of Allegiance. All right, good morning. Again, I'm Pamela Jo Hatley, and I'll be serving as the Land Use Hearing Officer, and this is the May 24th Land Use Hearing, Hillsborough County Land Use Hearing. And I'd like to introduce Tom Hisney with Development Services, and he will go over any changes to the agenda and introduce staff.
Good morning, Madam Hearing Master. My name is Tom Hisney, an Executive Planner with Development Services. To my left is Carmen Mason. She works on hearing operations staff for Development Services. We're also going to be joined virtually in this meeting by County Attorney staff, Cameron Clark and Mary Dorman. We'll also be joined virtually by a number of planners on the Development Services staff on the various cases. We have no changes to the agenda today, so I will now read the published withdrawals and continuances. Item A1, Variance Application 21-0305. The applicant is Orlando Huertas. This application is being continued by staff to the June 21st, 2020 Land Use Hearing Officer meeting. Item A2, Special Use Application 21-0306. The applicant is Costanera Peruvian Cuisine. This application is out of order to be heard and is being continued to the June 21st, 2021 Land Use Hearing Officer meeting. Item A3, Variance Application 21-0338. The applicant is Keith Bolton. This application is out of order to be heard and is being continued to the June 21st, 2021 Land Use Hearing Officer meeting. Application A4, Special Use 21-0375. The applicant is Trademark Metals Recycling, LLC. This application is out of order to be heard and is being continued to the June 21st, 2021 Land Use Hearing Officer meeting. Item A4, item A5, Variance Application 21-0498. The applicant is Roy Mazer. This application is out of order to be heard and is being continued to the June 21st, 2021 Land Use Hearing Officer meeting. Item A6, Variance Application 21-0532. Applicant is Nick Bracken. This application is being continued by the applicant to the June 21st, 2021 Land Use Hearing Officer meeting. Item A7, Variance Application 21-0549. The applicant is Evan Childs. This application is out of order to be heard and is being continued to the June 21st, 2021 Land Use Hearing Officer meeting. Item A8, Variance Application 21-0573. The applicant is Brandon R.E. Holdings, LLC. This application is out of order to be heard and is being continued to the June 21st, 2021 Land Use Hearing Officer meeting. Item A9, Special Use Application 21-0595. The applicant is Triple Taurus, LLC. This application is out of order to be heard and is being continued to the June 21st, 2021 Land Use Hearing Officer meeting. Item A10, Variance Application 21-0605. The applicant is David and Amanda Albaugh. This application is out of order to be heard and is being continued to the June 21st, 2021 Land Use Hearing Officer meeting. Item A11, Special Use Application 21-0606. The applicant is Dune FL Land One Sub LLC and South Shore Bay Club LLC. This application is being continued by staff to the June 21st, 2021 Land Use Hearing Officer meeting. Item A12, Envirotech Pest Control Services, Variance Application 21-0607. Applicant is Envirotech Pest Control Services Incorporated. This application is being continued by the applicant to the July 26, 2021 Land Use Hearing Officer meeting. And that concludes the withdrawals and continuances.
Thank you, Mr. Hisney. All right, I'm going to go over some meeting procedures first before we get started. First of all, and it was asked already, that if you have any devices that make noise, please silence them now. Today's agenda consists of items that require a public hearing by a hearing master. I will conduct a hearing on each item today and will submit and render a decision within 15 working days after the conclusion of today's public hearing. My decision will be filed with the clerk of the Board of County Commissioners. The hearings today will be informal. I will ask questions related to the scope of direct testimony and may call and question witnesses as I deem appropriate. I will decide all questions of procedure. I will take evidence, but will exclude evidence that is irrelevant, immaterial, or unduly repetitious. Evidence may be presented in written form, and all testimony shall be under oath. Hearsay evidence may be used to supplement or explain other evidence, but shall not be sufficient alone to support a finding of fact unless it would be admissible over objections in a civil court action. So the order of presentation today shall be as follows. For variances, Mr. Hisney will call the case, and then County Development Services will have 5 minutes to present its report and findings. The applicant and the applicant's witnesses will then have 15 minutes to present the proposal. Any proponents will have 15 minutes to present arguments in support of the proposal. And opponents will then have 15 minutes to present arguments against the proposal. County staff will have 5 minutes to present any amended findings or comments, and then the applicant will have 5 minutes for rebuttal and summation. For special use cases, Mr. Hisney will call the case, and then the applicant and the applicant's witnesses will have 15 minutes to present their proposal. County Development Services will have 5 minutes to present its report and findings. Planning Commission will have 5 minutes to present findings of compliance or non-compliance with the comprehensive plan. Proponents will have 15 minutes to present arguments in support of the proposal. Opponents will have 15 minutes to present arguments against the proposal. And then county staff will have 5 minutes to present any amended findings or comments. And the applicant will then have 5 minutes for rebuttal and summation. The 15 minutes that are allotted to proponents and opponents is the total allotted time among them. So if there are a number of persons who wish to speak, the 15 minutes will be distributed among those persons. If there's a spokesperson, you may want to designate someone then to represent the views of all of you. When you come to the microphone, please state your name and address for the record. The meeting is being recorded. We need you to please speak into the microphone so your testimony can be heard and recorded. And when you're finished speaking, please see the clerk who is sitting to my right to sign in for the record. Now we'll hear from the County Attorney's Office regarding legal requirements for procedures and appeal.
Good morning. This is Mary Dorman from the County Attorney's Office. This land use hearing officer public hearing is for variance and special use requests. This is the time for interested parties to present evidence and testimony. Once the hearing officer has closed the case, the record of that case is also closed, and no new evidence regarding that case may be submitted thereafter. Any decision by the hearing officer may be appealed to the Land Use Appeals Board. Should a decision of the hearing officer be appealed, the evidence and testimony presented at this public hearing shall be the only evidence that is subject to review by the Appeals Board. In reaching a final decision on petitions, the Appeals Board will only consider the decision of the hearing officer and the record made at this public hearing. If an appeal is filed, the Appeals Board hearing shall consist of oral arguments by the party appealing the decision, county staff, and any interveners, each of whom may be represented by legal counsel. The following shall have standing to appeal a decision of the hearing officer or to intervene in an appeal. 1, the applicant, or 2, anyone who appeared before the hearing officer, presented testimony or other evidence, and is adversely affected by the decision of the hearing officer. It is the role of the County Attorney's Office to ensure that no new evidence or testimony is allowed before the Appeals Board that was not presented to the hearing officer at today's hearing. The County Attorney will recommend that the Appeals Board disregard evidence or testimony that's outside of the record made at today's hearing. Any evidence presented to the appeals board that is outside the record today at today's hearing could jeopardize the legality of the appeals board decision, and the presenter of that evidence could hurt their own cause. The safest course of action, then, is for you to write down any comments you make today and repeat them to the appeals board. Thank you.
Thank you, Ms. Dorman. All right, all testimony today must be under oath. So if you plan to speak today, please stand and raise your right hand and I'll swear you in. Okay. And if you're on virtually, please also be sworn in. All right, do you swear or affirm the testimony you are about to give is the truth, the whole truth, and nothing but the truth?
I do.
Yes.
Thank you. All right, Mr. Hisney. First case.
Okay, we have no vested right cases, no fee waivers, no reconsideration requests. So that takes us to section E of the agenda. To site development variance request. The first case is item E1, variance application 21-0247. The applicant is Cheryl Kilcoyne, Double E Land Company, and Curry Investments Incorporated. The request is a variance to encroach into a wetland setback. Staff findings will be presented by Carla Shelton. Carla will present first. Carla?
It's actually Ryan Joyce with Natural Resource
Ryan.
Development Services. Good morning.
Sorry.
This applicant is requesting a variance from the 30-foot wetland conservation area setback requirement, section 4.01.07B of the Land Development Code. The applicant's specific request, as shown on the site plan submitted on April, the after-the-fact installation of a pavement with 30 wetland conservation area setback. Per LDC section 4.01.07.B.4, no filling, excavating, or placement of permanent structures, other impervious surfaces shall be allowed within a required 30-foot wetland conservation area setback. The applicant requests installation of pavement within the 30-foot wetland conservation area setback. The applicant requests a 29-foot reduction of the setback to allow for a setback of 1 foot. Findings are, this is an after-the-fact request. Encroachment is existing pavement that was put in place approximately 20 years. And that is all from Natural Resources.
Thank you, Mr. Joyce. All right, applicant, please.
Good morning, Madam Hearing Officer. My name is Chris McNeil with McNeil Engineering, address 15957 North Florida Avenue in Lutz, representing the applicant. The case this morning for the wetland reduction is for Bill Curry Ford, which is a longstanding dealership in the community. Has been here quite a few years and now currently operated by the third generation of Currys. And they are very involved and cherished in our community, so we're happy to represent that case. I wanted to give you a couple of slides, if I could move over to the Elmo here. Just didn't use that there. Thank you. The location of this site is at just north of Hillsborough on Dale Mabry on the east side. Perhaps you're familiar with it. But what you may not know is the multiple location or parcels that are involved with it. I just want to bring your attention to that as we believe this is part of the uniqueness of the site. It currently spans both the city and county jurisdiction, north and south side of the canal. It's separated kind of by the middle there with this blue line where you can see this is the Henry Canal. And the DOT and the dealership have worked quite well together over the past years. There's a bridge connecting with interconnectivity. There's also some other display area that's involved in there, and that's really what the focus is here today. There's also some areas north of Idlewild that are also part of the dealership as well. This is the area that we're currently focused on, which is in the county on the north side of Henry Canal. And that is where the existing encroachment is that we're asking for relief for. The site plan or the variance plan that was presented documents this existing location and how it is currently viewed. There's part of the request. That's a little tough to see, isn't it? That is in the DOT right away, but there's also encroachment if you were to take that offset for the existing display area on site as well. So we weren't quite exactly sure how to or what encroachment to request. So we just requested up to 1 foot, which is basically at the top of bank of the ditch or the Henry Canal. And so that's the way it's presented. So you can see that in this section. Actually, I'll show you the plan view a little bit better here with the aerial. Can you see that okay?
Yes.
Okay.
Well, when it clears up, yes.
There we go. So there's display area that's inside that right of way, which you can see that's in where the bridge is. So like I said, there's some the inner workings between the DOT and the dealership that has been allowed ever since it's been in existence. And so where that top of bank, that red line has been identified by the EPC as being there, the wetland line. And so the 30 feet would be from that location. You know what? Let me just do this. Is that easier to see?
That's fine. Thank you.
Okay. So that top of bank wetland line there, and you can see the 30-foot offset of where that falls. It falls slightly into the to the dealership property, but several feet of that is in the canal right away. These are two existing cross sections. How that responds or matches up with the canal. You can see both the top of bank, the asphalt encroachment, and then the small amount that's on site. From that, I do want to note one thing here before I move ahead is that not only are we asking for this for the existing building, or excuse me, the existing asphalt improvements, but there is also another general site plan or a PD case that I'll mention to you later for a building on the north side that we would also want to make sure this would apply to. I believe that it would, but the case was not filed before this application was made, so there wasn't any case associated with it at the time. Henry Canal improvements. The DOT is as part of our action for that PD that I just mentioned. We've met with the DOT in regards to access and connectivity for the future. And one of the comments that they made, which we're aware, and you may be as well, the Henry Canal is being improved, and it started on the far west side, and it's being improved all the way through. They initially started with embankment stabilization, but they've since changed their idea on how they're going to improve the canal at this location. In these comments that they gave us for the pre-application meeting, they said that the canal is in design and plans to start construction in 2022. When that happens, the ditch will be removed, and so there would be no need for a wetland setback at that time. But and I'll show you that here. Now, I do want to mention, even though they had this comment, we've had other correspondence with the DOT that may or may not be in 2022, but it's coming. So just want to point that out. This is a copy of their plan relative to the site directly adjacent. This plan view shows the area in the canal being converted to a box culvert, and it also shows an asphalt drive going around the perimeter of that canal property now. Yeah.
Yes.
Okay. It continues on. It goes further east, and basically this red line is the approximate location of where the east side of the property ends. This is a cross section of the canal. The red line at the bottom is the existing bottom of the ditch, and you can see it's being replaced by the two box culverts, very large box culverts, and then the top of finished grade will be that green line at the top. And so the ditch and the wetland will be effectively removed at that point. Again, 2022, perhaps, thereafter, but moving forward. This is a copy of the general site plan that was submitted for the rezoning case for the on-site portion there north of the canal. I've got the case reference there at the bottom for your reference. Part of this is not to get into too much detail unless you would like me to on this.
Well, this PD is not before me.
It's not. No,
And,
I'm just showing it as a point of reference because two things. One, on the application, it says, are there any other associated cases with this? This is an associated case, which was not on the application, but I wanted to make sure that the record was clarified that because it was not submitted at the time the application of variance was submitted. So I'm just making sure everybody knows that the PD case is it's in review. It's due to be heard sometime in the future.
And your comment a few moments ago, your question regarding whether this wetland setback impact decision will affect that, I don't know the answer to that question. We might ask the county attorney's office or Mr. Hisney to weigh in on that, but I don't know. Did you want that addressed this morning?
Well, so my understanding would be if the wetland setback reduction is approved, then it would be approved for now and in the future. Not necessarily tied to a particular.
For the impacts that we're talking about today.
Okay, so then we need to ask if I could show you the cross section so everybody sees that portion of it. This is a cross section of where the top of bank is relative to the proposed ramp that would lead up to the second floor parking deck of the new dealership expansion. And it's at 24 feet from top of bank. And so there is some, and I can go back to the site plan if we need to clarify exactly where that is.
Thank you.
I can also say too, it's on the variance plan shown that way. So this is a copy of the variance plan. And we're looking at this. This is the, this hatched area would be the ramp coming up to the second parking level. And this is the area that we're talking about.
So to be clear, is the request today then that the existing encroachment, which is pavement, plus this additional building that will be, or additional structures that will be added in the future are included in the encroachment that we're discussing today?
Yes, ma'am, that would be the intent.
Is that appropriate? Mr. Hisney?
I'm not personally involved in wetland setback reviews. However, I would ask Mr. Joyce, just generally speaking, if this request was simply for the existing encroachment, then I think that is relevant to the record. That, whether or not the request also proposed potential future improvements. And so I would ask Mr. Joyce to address that question as to what was requested in this variance.
All right, Mr. Joyce, can you speak up for us, please?
I would actually, Shelton, she's mine. Maybe she can answer that question.
Good morning. This is Carla Shelton with Natural Resources Development Services.
Carly, we're not hearing your mic. Can you move your mic up a little bit?
Is that better?
A little bit. It sounds like it might be selecting the wrong microphone. Next to the mute button, there's a little downward arrow.
Yeah, it is set on my headset. So I don't see any way I can turn it up. Okay, how about that?
Go ahead. We'll see if we could hear it already in person.
Okay. When this variance was submitted, the narrative and the application just specified that it was for the existing asphalt that are currently located in the 30-foot
But we
setback.
still can't hear her.
Yeah, we're not hearing you yet. Carla, that downward arrow next to the mute button, click on
Yes.
that, and then you
Yes.
click on settings.
Yes.
And under microphone, you can try to turn that up all the way and deselect automatically adjust the volume.
Okay, can you hear it any better now?
Not really, no.
How about now?
Yeah, it looks like it sounds like it's the wrong input selected. You may need to unplug the headset and plug it back in.
All right, hang on.
Look, now we have you.
Oh, okay. Sorry about that. Okay, when the application for this variance was submitted, the narrative and the application both specified that it was for the existing asphalt that are already located within the 30-foot setback area. The site plan that was submitted did show a structure that was not really identified on the plan as a future ramp to a parking garage. And last week, the applicant brought this to my attention. That ramp was not identified on the cross sections of the plans. So I asked Mr. McNeil to bring that. I told him we could either continue the case to clarify that, or he could bring it up at the hearing and submit revised site plans with the cross section that clarified that a ramp would be placed within the 30-foot setback area in the future.
Okay, that explains that. Thank you, Ms. Shelton.
Yes.
All right, and you have those with you today,
Yes,
and you'll
ma'am.
submit them into the record.
Yes, ma'am.
All right, thank you very much. Please
you.
continue.
Okay. Just to full circle, close the circle of communication on that. We can see on this variance plan the potential future part service with parking above, and the ramp identified here, but correct on the cross section. That cross section is referenced in the PD, and it's provided here that shows it from the top of bank approximately 24 feet from that property line, which is basically where the top of bank is. So, and it's a parking ramp above. There's I believe 3 columns along that side. Are there any questions about that?
I don't have any further questions for you.
Okay. Then just to close, I just want to walk through the 6 justifications just to make sure that they're conveyed well. The uniqueness and practicality of this is that the property spans multi jurisdictions. It's unified across the Henry Canal. We're not aware of any other properties that are like that, east and west. It's kind of a unique situation, and so that relationship with the DOT exists. And as a result from that, the neighboring properties that were developed subsequent and many years after the dealership were there all provide further distance from their original development from the canal. So I believe this was allowed at a time where that it wasn't as stringent, and even still, and now we're past the policy of reduced setback from other surface waters areas as opposed to meeting a 30-foot. So that's the uniqueness of the site. The depravity of the property owner. It's been there since '72, and the condition has been allowed for at least 20 years, if not more. And if it would be removed, it would negatively impact the display area and the future development potential, which have a direct correlation to the sales that they have. And of course, if the sales are reduced, then thereby have a negative impact on the dealership. The property owner should be able to enjoy the rights that they have been provided historically. So moving on to no substantial interference, the request of variance will not negatively impact or not interfere with or injure the rights of others because of the wetland setback reduction. Again, is solely between those two parcels with common ownership on both sides of the canal and only separated by the ditch.
Can you wrap up in about 2 minutes?
I can.
All right, thank you.
Yes, ma'am. Harmony and serve with the general intent purpose of the LEC and comp plan. The variance request will allow the existing use of the property to continue by providing reasonable use of the land in a manner that is consistent with its historical use and such not impose nor interfere with others. There's been no illegal action here. The site was originally constructed this way prior to implement and of the LEC requirements. And as such, there's no self-imposed hardship, but rather just a documenting of a longstanding condition. And the substantial justice that would be provided for the public and the property owner as the variance request documents have a longstanding condition. It's been in existence again for at least 25 years. The condition has no negative impact to the public or the community. The hardship created by imposing a 30-foot wetland setback from a drainage ditch or surface water other would be unjust to this longstanding dealership, which has been an asset to the community which it serves.
And actually, something did come to mind. I wanted to ask you just a couple of questions. You mentioned the canal is actually undergoing improvements and eventually will be replaced by a different drainage system, but it will no longer be a canal.
That's correct.
So at that point, will it no longer be considered a wetland?
That's correct.
Okay. Can you, do you know when this area was paved?
As far back as we can go on the aerial records, it exists that way.
Okay.
We believe it to exist back to the original dealership.
Okay. And how far?
72 is the original dealership.
All right.
And we know it's been there for at least, that's why I said at least 25 years because of the aerials.
Okay. That's all I had. Thank you.
Yes, ma'am. Oh,
And please submit those into the record and see the clerk right over here.
yes, ma'am. One last thing I'd like to say is no calls, no opposition. Haven't had anything from the public.
All right. Thank you. All right. Are there any persons here or online who wish to speak as proponents in favor of this item? Don't hear any. Are there
I
any?
believe Chris McNeil, this was E1?
This is E1. Is there someone who wishes to speak?
Chris McNeil, are you online?
Oh, all right. Chris McNeil is here.
Oh, I'm sorry, he isn't.
Thank you. Okay. Are there any persons here or online who wish to speak in opposition to this item? All right, don't see any. All right, back to development services. I believe Mr. Joyce, did you have anything further?
I did not.
All right. Applicant, did you have anything further? Okay. All right. That's a no. All right. Was that a no? All right. Thank you. That will close the hearing then on variance 21-0247. Mr. Hisney?
Our next case is item E2, variance application 21-0455. The applicant is Greg Barron. The request is a variance to the wetland setback. The staff findings will be presented by Ryan Joyce.
Ryan Joyce, Natural Resources Development Services. The applicant is requesting a variance from the 30-foot wetland conservation area setback requirement, section 4.01.07.b of the Land Development Code. The applicant's specific request, as shown on the site plan submitted on May 3rd, 2021, is to allow construction of a portion of a pool and deck within the 30-foot wetland conservation area setback. Per LDC section 4.01.07.b.4, no filling, excavating, or placement of permanent structures or other surfaces shall be allowed with a required 30-foot wetland conservation area setback. The applicant requests construction of a portion of a pool and deck within the 30-foot wetland conservation area setback. The applicant requests an 18-foot reduction to allow for a setback of 12 feet. Findings for this: there is a previous encroachment for a portion of the home and deck built in or around 2002. However, no permits or variances for this encroachment have been found. Therefore, existing encroachment is being included in this variance request. A wetland compensation planting plan has been provided to compensate for the existing encroachment, 699 square feet, and new encroachment of 347 square feet for a total of 1,046 square feet of planting. This request is to replace an existing screened deck with a new pool and deck area. That is it.
Thank you, Mr. Joyce. All right, we'll hear from the applicant.
Okay. Good morning. My name is Dr. Donald Richardson. I'm the owner of Ecological Consultants, Inc., 5121 Ehrlich Road, Suite 103A, Tampa, 33624. And I'm here today as the agent to Greg and his wife about the installation of the construction of a swimming pool within the 30-foot setback. And we have slides? Huh? Well, I guess I could do. On this drawing, the house was built in 2002, and you can see that portion of the house approximately, approximately 699 square feet of the house and pool deck were constructed in the wetland setback prior to the Barons buying the house. So what they have opted to do to reduce the impacts is to create a swimming pool that doesn't go any closer to the wetland line, which you can see here. This line is the wetland line. This line is the setback line, and you can see that it runs through the house. So what we are proposing is to add approximately 217 square feet of pool within the existing canopy deck, and then add 347 square feet.
Try to stay in the microphone, please.
Okay. An additional 347 square feet sort of east, if I can find the drawing here. What I want to do is show you that. The top drawing shows you on the right-hand side the existing pool deck and wall. And 12 feet from the edge of that deck is the wetland line, the closest point to the wetland line, which was recently established by EPC. And from a historical perspective, when the Edenborough subdivision was created, the wetland line was identified. And then because of the proposed variance and construction of the pool, it was reset within a few feet of where it was originally. So the client is proposing, if you look on the lower drawing here, is to add 347 square feet out to about this stump here and then back to the house. So in essence, he's going to have about 1,047 or whatever square feet of impact that we are going to offset by providing a planting plan for the impacts. I'll show you this. Right there, you can see that the proposed pool will have 347 square feet of impact in the existing buffer, no closer to the wetland line than the existing deck. It will have 217 square feet of impact within the existing cage pool. And we are also providing compensation for the remainder or that original 699 that for whatever reason was not taken up into consideration at the time the CO was given. I'm sure, even though I could not find any records, that the house, when it was built, must have had review by EPC, but there just is no file. So as a result, we are proposing to plant approximately 1,046 square feet of new plantings, which will go into the existing sod yard. So in summary, because this is a fairly straightforward, I think, approach, the impacts will be no closer to the wetland line. We are offsetting all of the impacts within the existing structure and the new 347 extends out of the deck with native wetland plantings that will provide better water quality to the lake, will reduce nutrient loading, and will provide wildlife habitat for animals that move along the lakeshore, which now have to traverse yards that have sod. So we feel that this plan provides the required compensation. And I'd just like to add that the owners, when they bought the home, were not assured, but there was discussion that said that they could eventually build a pool. And they are finally getting to the point where we are actually going to build a pool. So, but the one thing that I think is important here is that the additional 347 square feet that is going to be constructed outside of the existing impact in the lower drawing here is actually within his yard. So from that, on the left-hand side over here, that corner is the closest to the wetland line that we have, and the rest of the pool will be constructed and then angle up to the house. So in summary, I think it provides all the requirements of the rule. It increases the wildlife advantages and the water quality. And at that time, I'd like to just turn it over to the owner if I could.
Well, I have just a couple of questions for you for clarity. So there is an existing pool.
No, there is no pool.
There's not.
There's an
just a
existing deck and covered, I guess, screen room.
Okay.
Yeah.
And so that part of the structure encroaches into the wetland setback line.
Excuse me, Madam Hearing Master. Would you please cover your face with the
Oh,
mask?
sorry.
Thank you.
Sorry.
Yeah, and nose as well.
Yeah.
Thank you.
Thank you.
Yeah.
So the existing structure is what encroaches into the wetland setback line.
Yes, you can see in that top drawing there, that the screen room and deck
Yes, I see it.
is in the setback. Now, one thing I forgot to add, which I think may be important, is that the pool is only 4 feet deep and it's not going to be excavated in the ground. We did from the ground up. So I guess it just doesn't want to stay there.
Perhaps if you tighten your straps. it'll stay.
Yeah. So anyway.
Okay, so while you're adjusting, then my question, just for clarity, because I believe I understand, but so what's going on now is the owner is in that area building a pool, but also extending the structure out. And so it will impact an additional, something like 347
Yes.
square feet.
Yes, ma'am.
So it's not getting any closer to the
No.
wetland, but it is impacting additional 347 square feet of the wetland setback area.
Yes.
Okay, thank you. I understand.
Okay.
And the owner wishes to come forward?
Yeah. Good morning. Greg Barron. 15203 Leaf Walk Lane, Tampa 33618. And I think Don covered just about everything that I think is important here. And we have approval from our HOA because the design of this pool gets very close, right on the edge to the drainage easement, but they've signed off on that, as have they signed off on the design and have expressed this being a very desirable addition to the neighborhood. It's a small neighborhood of only 14 homes. And so in speaking with our neighbors and the HOA, they've approved it. So I think Don's covered just about all the very specific evidence pieces. Just reiterating that there is that one-to-one replacement of the native plants, which is going to do not only the new impact, but what's been there since 2002. We're the third owner, and unfortunately, we had a little misinformation along the way in our buying process, which is no fault of the counties, but we relied on some of that. Any questions for me?
Don't have any questions for you. Thank you.
Thank you.
All right, Development Services, is that Mr. Joyce? No, we heard from Mr. Joyce. I'm getting mixed up in the process. Okay. Are there any persons here or online who wish to speak as proponents in support of this item? All right. Don't hear any. Are there any persons here or online who wish to speak in opposition to this item? All right, don't hear any. Anything further from Development Services, Mr. Joyce?
Nothing further.
Thank you. And anything further from the applicant? Okay, thank you. That's a no. All right, this will close the hearing on variance 21-0455.
That concludes section E of our agenda. We'll now move to section F, which are the signed variances requests. First case is item F1, variance application 21-0410. The applicant is Saglo Development Corporation. They are requesting a sign variance. The staff report was prepared by Kim King, but I will be presenting the findings at today's hearing. The applicant is requesting variances to allow additional sign area and a reduced setback for an existing monument sign. This request is for the Sunpoint Plaza located at 3002 East College Avenue. Now, the subject parcel is allowed to have one sign on College Avenue, one sign on Tico Road, and two signs on 30th Street Southeast. Or the code provides for a property owner to combine all those signs into one sign, which is the case here. And by code, that one sign could have 100 square feet of display area or sign area on each side for 200 square feet total. Also, with regards to setback, a monument sign on an arterial road is allowed to have a maximum height of 30 feet. A monument sign of 4 feet requires a 15-foot setback. And for every 1 foot of sign height, you increase the setback by 1 foot. So the variances are as follows. The applicant is requesting 230 square feet of additional sign area for a total of 430 square feet for the existing monument sign. And then the applicant is also requesting a setback variance of 29 feet from the College Avenue right-of-way line to allow a setback of 12 feet and a variance of 26 feet from the Tico Road right-of-way line to allow a setback of 15 feet. And if you look at the graphics that are in the report, let's see here, you'll see what they're doing is they're slightly modifying that existing sign. It would be in your, I believe, in your the backup that's in optics. But anyway, that concludes the staff findings.
Thank you, Mr. Hisney. All right, we'll hear from the applicant.
Hello, this is George Morell. Can you hear me okay?
Yes.
So Jorge, Morell is Morell. I'm the Vice President of Property Management for Sagler Development. You know, the presentation made, of course, summarizes our request very accurately. We purchased this shopping center in approximately 2014 and are, you know, slowly but surely making our way through leasing it up completely. We've added some national tenants, Fresnius Dialysis Center, Harbor Freight opened up in late January. We've continued to beautify the center. We brought it up to ADA compliance, added a connectivity route along the side road, etc. So if you look at the sign, the last sort of eyesore that exists at that center is the sign. And as the graphics will show, we're looking just to beautify the sign, to add you know, a metal cap sheet at the top, impose the name of the Sunpoint Plaza Center. Going to install LED lights to make sure it's you know, lit at night, etc. And you know, this is all in conjunction, of course, with like every other real estate owner dealing with the COVID pandemic and trying to help the large number of mom and pop tenants that exist at this center just, you know, make it through the wave of difficulty that they're going through. So again, the sign is existing. We're looking to just beautify it. We don't see any, of course, you know, negative ramifications if the county you know, grants our request. On the contrary, if you go by the center, this and then additional landscaping upgrades that we're going to make constitute the last sort of, again, overdue eyesores at the center and on this sign. So again, we respectfully request that the county you know, grant our variance accordingly. And any questions, of course, I have my construction representative also on the line, but any questions, we'll certainly be happy to answer them accordingly.
Can you just give us your address for the record?
Certainly. It's 290 Northwest 165th Street, Penthouse 2, Miami, Florida 33169.
Thank you.
All right. Thank you, Mr. Morell. I do not have any questions for you, actually.
Thank you very much.
Okay. All right. Are there any persons here or online who wish to speak as proponents in support of this item? Don't see any. Are there any persons here or online who wish to speak in opposition to this item? Do not hear any. All right. Anything further from Development Services?
No, ma'am.
Anything further from the applicant?
No, thank you, ma'am.
All right. Thank you. This will close the hearing on variance 21-0410.
All right, next case is item F2, variance application 21-0500. The applicant is Covenant Catalytic Church. The request is for a sign variance. Staff report was prepared by Kim King. I will be presenting the findings at today's hearing. The applicant is requesting variances to allow additional sign area and a reduced setback for an existing monument sign. This request is for the Covenant Catalytic Church located at 6212 North 47th Street. The subject parcel is zoned RSC9 and is allowed one monument sign for a residential support use, which includes churches, at 16 square feet per side or 32 square feet total, and with a maximum height of 8 feet. A monument sign of 4 feet requires a 15-foot setback from the right-of-way line, and for every 1 foot of increased height, the setback requirement increases 1 foot. So the variance is as follows. The applicant is requesting 34 square feet of additional sign area for a total of 66 square feet. And then the applicant is also requesting a setback variance of 14 feet from the right-of-way line to allow the sign to be placed at 4 feet. The sign was installed before 1988 and apparently was recently struck by a car and therefore needs to be replaced. And that's it for staff findings.
Thank you, Mr. Hisney. All right, we'll hear from the applicant.
Good morning. My name's Mark Brinchley. I live at 3790 Beacon Ridge Way, Claremont, Florida, 34711. I'm not sure if the presentation from staff made it clear this is a replacement of a damaged sign. This is the current status of that sign. Damaged in the late summer 2019. The county refused to allow them to repair it and rebuild it because it doesn't comply to the setback ordinance. And so I'll show the location. These two buildings were built in 1966. The church purchased this property in 1999, and the sign had been there since images I found on Google since January 23rd, 1995. And I could present these Google images if you wish, but the sign has been there for 26 years until it was destroyed by an automobile and they wish to reconstruct. This is and the reason they wanted to go there, they wish to use the existing footings. There's a copy of the image before it was destroyed. And then this is the proposed sign using the exact same columns and the body of the sign. They only wishing to add the arch on top, adding the words Our Jerusalem. Otherwise, the sign is exactly as it has been for the past 26 years. All the conditions and findings of fact within the ordinance have been found to be positive, and it is a hardship for this particular church to move this sign to the conforming setback, because that would move it into the middle of the driveway, as you see. And the sign is also really a historical marker for the community that has been there 26 years. And they wish to put that back as a wayfinding, as well as an identification sign, as well as a landmark for this community that has been revolving around this particular building and now for 50, 60 some years. Any questions?
I don't have any questions for you. Thank you. Sir, I do need you to, Mr. Brinchley, could you please sign in with the clerk? Thank you. All right, is there anyone here or online who wishes to speak as a proponent in support of this item? All right, is there anyone here or online who wishes to speak in opposition to this item? Don't see any. Okay. Development Services, anything further?
No, ma'am.
All right. Applicant, did you have anything further? No, thank you. Okay. That will conclude then the hearing on variance 21-0500.
Okay, that concludes section F of the agenda. Now takes us to section G, general variance requests. First item is G1, variance application 21-0385. The applicant is Teresa McDonald Kirby. The request is a variance to subdivision standards and to site development standards. Staff findings will be presented by Kevy DeFrank.
Good morning, everyone. Kevy DeFrank with Development Services. For this case, the applicant is requesting variances to accommodate a proposed 3-lot subdivision and for the setback of an existing single-family home on property zoned AS1 that is located in the rural service area. Now, for the variance associated with the proposed subdivision, the Land Development Code states that privately owned access easements may be included in lot width calculations, but shall not be included in calculating compliance with the minimum lot area required for individual lots. Specifically, the applicant requests a variance to allow the area within the access easement for the proposed subdivision to be included in the minimum lot area calculations for lots 1 and 2. For the proposed lot 1, it will allow for 6,425 square feet of easement area to be included in the proposed lot size of 1.032 acres. For the proposed lot 2, it will allow 4,886 square feet of easement area to be included in the proposed lot size of 1.105 acres. And no variance is requested for lot 3, which has a proposed lot size of 1 acre and includes no easement area. Now, for the proposed variance associated with the existing home, the Land Development Code states a minimum front yard setback of 50 feet is required in the AS1 district. And specifically, the applicant requests a 15.8 foot reduction to the required front yard to allow a front setback of 34.2 feet from the south property line for the existing home on the property that will be located on the lot 1 of the proposed subdivision. And no other variances have been requested by the applicant to subdivision and site development requirements. And that concludes my report and findings, and I'm available for questions. Thank you.
Thank you, Mr. DeFrank. All right, we'll hear from the applicant.
Hi, my name is Amber. My address is 2002 Holloway Road.
Amber, you're breaking up there a little bit. Could you restart?
Yes. Is that better?
No, it's we're getting some weird audio there. Let me try muting you and unmuting you. 1 second. Try one more time.
Are we good?
We're still getting some weird audio there. It sounds like it's I'm not sure if you have a different microphone there or if you're using a microphone. You could try pulling it out and putting it back in.
No, I'm not.
Okay, let's have you try leaving the meeting and rejoining. Amber, can you hear us?
I can.
It seems like it's cleared up a little bit.
Okay.
Can you just enable your camera as well?
Okay. Ugh. Okay.
Can we have you say something just to hear your audio again?
Okay, can you hear me?
You should say it one more time.
Can you hear me?
Yes.
Okay. Am I okay to start?
That's not going to work.
Okay, yeah, I'm sorry, Amber. We're having audios come through. If you have a cell phone there, I could give you the number to call in real quick.
I do. Sorry.
Okay, I'm gonna mute you here just so you can hear me. The call-in number will be 1408-418-9388, and you'll put in the meeting number. And that meeting number will be 173-947-7741. And you could just hit pound when it asks for the ID number. Amber, can you hear us?
I can.
Okay, now we're good. Go ahead.
Okay, so my name is Amber 2. My address is 2002 Holloway Road, Plant City, Florida 33567. I'm the representing agent for Ms. Kirby. As Mr. DeFrank said, we are requesting a variance to allow a privately owned access easement to be included in calculating the minimum lot area for lots 1 and 2 in Ms. Kirby's proposed 3-lot minor subdivision. And we're also requesting a minimum front yard setback variance for Ms. Kirby's home that was built in 1961. The proposed lot 1 of her minor sub will have her current home on it. We are asking for a 15.8-foot reduction for her front yard setback. Ms. Kirby is proposing this 3-lot minor subdivision so that her children will be able to build on the proposed lots 2 and 3 to be close to her to help care for when the need arises.
All right, is that it, Ms. Tu?
Yes, ma'am.
All right, thank you. So the request for setback variance, that is for the house on Lot 1, and that's the existing house that was built in 1961. Is that correct?
Yes, ma'am.
Okay, thank you. That's the only question I have for you.
Oh, you're welcome. Thank you.
All right, thank you. All right, are there any, is anyone in the room or online who wishes to speak as a proponent in support of this item? All right, is there anyone in the room or online who wishes to speak in opposition to this item? I don't hear anyone. Development Services, Mr. DeFrank, anything further?
No, nothing further.
All right, thank you. Applicant, anything further?
No, ma'am.
All right, thank you. That closes the hearing then on item 21-0385.
All right, next case is item G2, variance application 21-0400. The applicant is Denise Lee Sanchez and Visa Law. The request is a variance to accessory dwelling requirements. Staff findings will be presented by Tanya Chapella.
Good morning. This is Tanya Chapella, Development Services. The applicant seeks setback variances for an existing accessory dwelling on a lot zone RSC 9. The required minimum rear yard setback for property zone RSC 9 is 20 feet. The applicant requests a 15-foot reduction to the required setback to allow a rear setback of 5 feet from the west property line. The required minimum side yard setback for property zone RSC 9 is 5 feet. The applicant requests a 1.7-foot reduction to the required setback to allow a side setback of 3.3 feet from the south property line. The subject accessory dwelling was created from a detached garage without building permits. Therefore, if the requested variances are approved, the property owner must obtain after-the-fact building permits. Per the Land Development Code, Section 61102C, a maximum of 900 square feet of living space is permitted in an accessory dwelling, and a variance to increase that amount may not be requested in this case. The subject accessory dwelling has approximately 946 square feet of living space. Therefore, if the subject variance is approved, the property owner must structurally modify the accessory dwelling to reduce the amount of living space pursuant to Section 61102C to a maximum of 900 square feet as measured from the exterior walls of the structure. Staff recommends that a condition be placed on the subject variance, if approved, to require that the modifications be completed within 90 days, of the approval date of this variance. The property owner's representative does not object to this condition. If the subject variance is not approved, the property owner must modify the subject structure so that it no longer constitutes an accessory dwelling as regulated by the Land Development Code, and the structure cannot be utilized for independent living quarters or for sleeping purposes at any time, including guest visits. The building will then be subject to regulation as an accessory structure. However, at this present size, the building covers more than 20% of the required rear yard area on the property as permitted by Land Development Code Section 61104C3. Therefore, approval of a variance through a separate application from the subject request must be obtained to maintain the present size of the building for use as an accessory structure. As an alternative, the property owner may reduce the size of the building to comply with rear yard coverage requirements. The calculations for which must include all other accessory structures on the property which occupy the required rear yard. This completes my presentations. I'm available for any questions.
Thank you, Ms. Chapella. All right, we'll hear from the applicant. Yes, please.
Madam Hearing Master, good morning. Mr. Hisney, good morning. County Attorney, staff, good morning. Thank you for your time. My name is Victor Zamora. I represent Denny Slay Sanchez. He's the homeowner located at 7518 Blossom Ave, Tampa, Florida, which is the subject of this variance. My address is 1924 West Dr. Martin Luther King Jr. Boulevard, Tampa, Florida, 33607. First, I want to thank Mr. Hisney, Ms. Chapella's involvement and cooperation in this case from the very beginning. They've been very proactive in assisting me in trying to get to this point. So I want to say thank you. Secondly, as you can tell from Ms. Chapella's narrative, if you will, there's a lot of moving parts. This residence, the main residence, was built in 1967. The property was purchased by my client in 2017. At the time of the purchase, there were two accessory structures already located in the rear of the yard. One of them, which is the subject of this application, and a smaller garage unit located towards the back north side of the residence. If I may use the For the record, we will. This one? And for the record, we're going to identify this site plan.
And try to speak into the microphone,
I
please.
apologize. For the record, I've just identified this site plan as Exhibit A.
Thank you.
Let the record reflect that the subject accessory dwelling is going to be identified by the. Yeah, let's do it like this. I apologize. Let the record reflect that I've identified the accessory dwelling, which is currently existing, by a delta that I've marked. That was a garage, which was extended. This is going to be identified as Exhibit B. This is currently how the dwelling looks like from the exterior. To the left, where I'm pointing now, that's what was existing currently on the property when my client purchased it. This what was done and adding it. What we're requesting is that the accessory dwelling continue to exist on the property, obviously on the condition that all permits are complied with and obtained, which is currently in the process. Obviously, they need to wait to see what happens by this body and the decision that this body makes. Obviously, we're requesting a variance from the setback to the rear of the property, and obviously the north side of the property as well. Excuse me, the south side of the property. The current condition of the property, it was purchased back in 2017. There is a smaller unit, which we don't have a picture of, which occupies a certain square footage. If you were to take the square footage, I don't have the exact measurements, but if you take the square footage of the little garage unit and the north side of the property with the square footage of the garage as it existed when it was purchased by my client before the addition, it would also extend past 900 square feet. So what we have here is a property owner that purchased this property in 2017, already not in compliance with Hillsborough County Land Development Code. Obviously, if the variance is not approved by this body, my client would have to expend additional money and additional services to reconstruct that whole that unit and take away a substantial part of what is currently existing. That would create more of a nuisance, more of a headache to surrounding landowners, including noise.
Mr. Samora,
Yes, ma'am.
we need you to stay closer to the microphone,
I
please.
apologize.
Thank you.
So if this board does not approve this variance, it's going to create more of a nuisance and more of a headache for the surrounding neighbors as well as my client, which has spent a substantial amount of money to bring this into to put it to what it is right now. I'm going to show you inside the residence. Let the record reflect, I'm marking this as Exhibit C. As you can tell, it's done professionally. It's aesthetically pleasing. It's not a garage that would just haphazardly turn into a living residence. I'm marking this as Exhibit D. Again, you could tell that it's clean, it's aesthetically pleasing. It wasn't done in an unprofessional manner. Exhibit E, the kitchen. And Exhibit F, the living room, excuse me. That's Exhibit F. Exhibit G is the exterior of the residence. Exhibit H is concerning a portion of the variance that we're requesting. As you can tell, it doesn't interfere with the fence line of the adjoining neighbors. It's not so close to the property line where nobody could There's no ingress or egress being prohibited from the distance that we're requesting to be the subject of this variance. Obviously, if this board, as Ms. Chappella told us, if this board does grant the variance, my client has no objection to bringing the building within the 900 square foot requirement within 90 days. Plans have been already made, so that could be done as efficiently and expeditiously as possible. So that's not going to be an issue. Obviously, there is something else that if we do get to that point and we do get this variance, another variance is going to be required in order to obtain permission from this body to allow more than 20% of the rear property to be. Mr. Hisney, I see you shaking your head. Is there a question?
Yeah, I just want to advise you that the 20% rear yard coverage only comes into play if this variance is denied. Accessory dwellings aren't subject to that 20% required rear yard coverage, only because they are required to meet principal building setbacks. So without a variance, they actually wouldn't be in the required rear yard. So what comes into play on that required rear yard coverage is if this variance is denied, in which case you must then convert the structure back to an accessory structure, then that's when that required rear yard coverage will come into play. And you would have at that time seek another variance or reduce the size of the structure so that this structure, and then I think you said there's another accessory structure.
That's correct.
Smaller one in the backyard as well?
Which is not part of this application because it was never at issue.
Correct. But those together, if this variance is denied, it would have to be no more than 20% of the required rear yard, which is not your entire rear yard.
That's correct.
Right. But that won't come into play for the accessory dwelling. If this is approved, then you're going to get the variances. This variance will, the setback variances will accommodate the accessory dwelling, but you will have to reduce the amount of living area. Yeah.
And Madam Hearing Officer, based upon what Mr. Hisney is saying, there's going to be extreme financial difficulties and hardship whether this application is or this variance is denied or approved. If it's approved, we've already made additional accommodations to come into compliance with the 900 square feet. Permits are already just waiting to be obtained based on this. So my client wants to do the right thing. He wants to come into compliance. He is a business owner here in Tampa. He's a father of two. He's put some money into this property, and it was done in a workmanlike manner. It was done professionally. I don't know if anybody's here in opposition, but I've not heard from anybody opposing this. He wants to do the right thing. Secondly, if this board does not approve it, there's going to be even further financial hardship to bring this property into compliance. When he bought it, he thought everything was okay. He's going to have to make substantial changes to the rear of the property to come into compliance on a property that he thought was A-okay. So there's going to be hardships on both sides of this, whether it's approved or not. So what I'm asking this board is to, based upon the narrative that was provided by Ms. Chappella, that we get that variance. Let's not put good money on top of bad. Let's put good money. Let's come into compliance. He's a property owner. He wants to make it pretty. It's done, as you can see, it's done nicely. He wants to bring more aesthetics to the community. Let me conclude by addressing the 6 criteria as per the Land Development Code.
You have 6 minutes, Mr. Zamora.
Thank you, ma'am. Obviously, I may be repeating myself, but in regards to the hardships and practical difficulties, obviously it's unique to this subject property because there were 2 accessory structures that were currently on the property when he bought it. Obviously, he converted one garage unit into an accessory dwelling unit in order to house additional family members. It was done in a workmanlike manner. I don't believe there is any issues of nuisance or the construction being done late at night. It was done by professionals. We're on the way to get our permits done. It was done in the hopes of trying to beautify his home. If you could ask code enforcement, they've been to the property numerous times. They've been more than helpful in this. They could attest to the fact that the property is not in shambles. It's currently in a nice state, so to say. So the hardships will also include the money that needs to be expended on bringing this into compliance if this variance is approved. Obviously, more money, good money on top of bad is going to be poured in if this variance is not approved. And it's not fair. There's no right for, doesn't make any sense for a landowner that purchased a property in 2017 to spend money on a property that he thought was in compliance, when that should have been the responsibility of the prior owner. But obviously that wasn't brought to this board's attention for whatever reason. Now my client has to bear the brunt. Secondly, in regards to the rights that my client is enjoying, obviously the Land Development Code should allow the property owner to use their property and enjoy the property as they see fit. This is not an issue of nuisances, overcrowding, property. He just wants additional family members to live in the accessory dwelling, and it's not encroaching. There's no overhanging structures on the adjoining neighbor's property. It's all encapsulated in his rear yard. Again, this is not interfering with any of the adjacent neighbors. There's no opposition. There's never been an issue of multiple people coming and going out of the property, creating a nuisance, creating a disturbance in the neighborhood. If this variance is approved, nobody's going to be affected or affected negatively if this variance is approved. Actually, however, if it's not approved, the requirement of construction and additional workers coming into the property and creating a mess to try to bring this property and the structure into compliance actually would affect the neighbors. You're going to have trucks coming in, bringing rubble, tearing down a mass portion of this dwelling unit. And it's actually, if this variance is not approved, this could affect the neighbors negatively. May I have a moment? This doesn't result from an illegal act. It's a miscommunication, so to say. My client thought that he purchased a property with two structures that were in compliance with the Land Development Code. He wanted to beautify the rear yard. It was done in a workmanlike manner. And obviously by the fact that he's retained counsel and I'm here, and that correspondences have been going back and forth with county officials, code enforcement, the fact that permits are just waiting to be obtained. We're trying to do the right thing. My client wants to do the right thing. He's not ignoring. He's been compliant with code enforcement. We want to do the right thing and we want to get this ball rolling.
Mr. Zamora?
Yes, ma'am.
When was the structure converted from a garage to a dwelling unit?
Based upon my records, and I believe within probably about a year ago.
Okay.
If I look at the...
So 2020, sometime in 2020?
That's correct, ma'am.
And who did that work?
I don't have that information on hand, but I'd be more than happy to supplement that information to this body if permitted.
Did Mr. Sanchez do it himself?
No, he did not. He retained a general contractor who I believe is going to be the one that's going to be taking out the permits if this variance is approved. And I'd be more than happy to get that information for you.
And obviously there's plumbing and electricity service to this building.
Yes, ma'am. AC, running water, hot water, electricity.
Okay. Is there a code enforcement action at the present time?
There is, Your Honor. I believe that is case number CE 21-000-263. And it's currently assigned to John Carrion, who's also been in the loop, so to say, from the beginning of this case.
All right. That's all the questions I have for you. Did you have anything further?
No, ma'am.
Okay. Are you going to submit those photographs into the record?
Yes, ma'am.
Okay. Just need you to sign in with the clerk here, and the clerk will accept the photograph.
Thank you, ma'am.
Thank you. All right. Is there anyone here or online who wishes to speak in support of this item? All right. Is there anyone here or online who wishes to speak in opposition to this item? Don't see anyone. Ms. Chappella, did you have anything further?
Nothing further.
Okay. Mr. Zamora, did you have anything further?
No, ma'am. Thank you for your time.
All right, thank you. All right, this closes the hearing then on variance 21-0400.
All right, our next case is item G3, variance application 21-0531. The applicant is Matthew, Jessica, and Thomas Nartker. And the request is a variance to lot development standards. Staff findings will be presented by Chris Grangillard.
Good morning. I'm Chris Grangillard, planner with Development Services. I'm here to present application variance 21-0531. The applicant is requesting setback variance to accommodate a proposed garage addition to existing single-family dwelling on a corner lot zoned PD Plan Development 73-0078. The variance, the conditions of approval and general site plan for PD 73-0078 do not identify the required minimum building setbacks for the subject lot. However, staff has determined the minimum required front yard setback is 20 feet. The applicant requests an 18-foot reduction to the required front setback to allow a 2-foot setback from the southeasterly property line along Tampa Shores Boulevard. Here are the findings. The applicant's survey indicates the existing home is located 7.1 feet from the northwesterly lot line, where there is a required side yard setback of 7.5 feet. The applicant elected to not include a setback variance for that encroachment in this application. Also, 2 sheds in the side yard do not meet accessory structure setback requirements. The applicant elected to also not include setback variances for those structures in this application and has advised staff that they will be demolished. That concludes my staff report. We're glad to answer any questions. Thank you.
Thank you, Mr. Grangillard. All right, we'll hear from the applicant.
Yes, hello. My name is Matthew Narker. I live at 10702 Drummond Road. And I'm asking for a 18-foot variance setback to build a 2-car garage on my existing lot attached to my current single-family home.
All right, do you want to address the variance hardship criteria?
Yes, with the way my house was built in 1964, they put it kind of at an angle on a corner lot, and being on a corner, I have 2 front yard variant or setbacks of 20 foot, opposed to the other side of my yard, which has a 7.5 foot. The variance I'm asking for is only at the very corner of the lot, and it will get bigger as the back of the garage runs down my property line, because it will still run at the same angle as my house is built on in the lot. We moved into the house almost about 11 years ago. We've grown, just trying to build something to house our vehicles now and secure our home.
All right, thank you. Is there a garage in the house already?
There is currently a 1-car garage that is also our laundry room / storage that isn't even really big enough for a car at the time.
Okay. Anything further?
No, ma'am.
All right. Thank you. Just stand by and we'll come back to you in a minute.
Okay.
All right. Is there anyone here in the room or online who wishes to speak in support of this item? Is there anyone here in the room or online who wishes to speak in opposition to this item? All right. Don't hear anyone. Development Services, anything further?
Nothing further.
All right. All right, Mr. Nartger, did you have anything further you wanted to add?
No, ma'am. Thank you.
All right, thank you. This will close the hearing then on variance 21-0531.
Okay, our next case is item G4, variance application 21-0566. The applicant is Daniel Zimmerman. The request is a variance to accessory structure requirements. Staff findings will be presented by Tanya Chapella.
Tanya Chapella, Development Services. The applicant is requesting a variance for a proposed detached garage on a single-family lot, zone ASC1. Per Land Development Code, Section 61104C1, accessory structures shall not be erected in any required front yard with some exceptions that are not applicable to this request. Accessory structures shall be permitted in front yards at twice the depth of the required front yard or 50 feet, whichever is less. The required minimum front yard setback for property zone ASC1 is 50 feet. Therefore, the required setback for the proposed garage is 50 feet. The applicant requests a 5-foot reduction to the required setback to allow a front setback of 45 feet from the west property line. According to the applicant, the proposed garage will not exceed 15 feet height. For the submitted survey, the existing single-family home on the subject property encroaches into the required 15-foot side yard on the north side of the parcel. However, the applicant has elected not to include the setback encroachment in the subject variance application. This concludes my presentation. I'm available for questions if you have any. Thank you.
Thank you, Mr. Pella. All right, we'll hear from the applicant. Okay.
Good morning. My name is Rebecca Johns, counsel for the applicant, 201 North Franklin Street, Suite 2000, Tampa 33601. The applicant is asking for a variance in order to construct a garage at his home. This property is odd in that it has a that's going to show. It's got a floodway that slants across the back of the property. So in order to avoid the floodway, it has to encroach into the front setback, and it can't, you can see it right there. This is the floodway line. This is the current house. This would be the proposed garage. There's also a well in between where the proposed garage is and the house, so you can't move the proposed garage over anymore. So it's just a bad shape for this property in order to construct anything. The property owner does own all of the property on the other side of the garage, so there will not be any neighbors that are right up on the garage. The property owner is here if you have any questions.
I don't believe I have any questions for you. Thank you. All right, is there anyone, and Ms. John, be sure to sign in with the clerk. Thank you. Is there anyone here or online who wishes to speak in support of this item? Don't hear anyone. Is there anyone here or online who wishes to speak in opposition to this item? Don't believe so. All right, Development Services, do you have anything further?
Nothing further.
Thank you. Ms. John, did you want to add anything further?
No, ma'am. Thank you.
All right, thank you. This will close the hearing on variance 21-0566.
Okay, our next case is item G5, variance application 21-0586. The applicant is April Lott, and they are requesting a variance to easement access requirements. Staff findings will be presented by Colleen Marshall.
Good morning, Colleen Marshall, Development Services. The applicant's requesting a 10-foot reduction to the minimum required easement width of 30 feet to allow a 20-foot wide easement to serve 2 dwelling units. The subject properties are accessed from Sheldon Road via Hyder Joe Lane, a private road easement which crosses the property to the west under folio 4672.0000. Be happy to answer any questions.
Thank you, Ms. Marshall. All right, we'll hear from the applicant.
You could hit the button to turn the mic on.
Okay. Hi, good morning. My name is April Lott, and I'm one of the property owners of the property located at 8710 Hyder-Joe Lane. I've also been asked to represent the owners of 8704 Hyder-Joe Lane as well. We're here this morning to request a variance to easement access requirements to reduce the required easement that serves two dwellings from 30 feet to 20 feet. The current easement, which has been in place since August of 1996, is the only access to both of our properties and was in place prior to either of us obtaining ownership of the properties. There are no property owners that would have a direct impact by granting the variance, including the complainant. To not grant this variance will deprive all owners access to their homes. Apparently, there was a mistake on an application that was submitted to Hillsborough County prior to us owning the property. That was an oversight. And there are some neighbors, and I guess we have an unfriendly relationship. So that's what brought us here today. I thank you for your consideration.
Thank you, ma'am. One question for you. You said the easement was created in 1996.
Yes.
How was it created? Was there an easement agreement? Is there something?
There was an easement agreement that was canceled and another easement reestablished. So the original existing easement was 30 feet wide. When they moved it from the center of their property over to the northern side, it was reduced by the 10 feet. And I'm not here, he's not here to speak for himself, so I'm not sure if he was aware of that 10 feet decrease or not. So.
And the easement agreement, is that in the record?
It is, yes. And I have a copy if you need it.
As long as it's in the record, I'll see it.
I don't think it is.
Well, would you submit it today then?
I will, yes.
Okay. Then I need you to sign in with the clerk, and also the clerk can accept that.
Okay, so
for the
let me
record.
just get it.
Yes. She'll be back. All right. Is there anyone in the room or online who wishes to speak in support of this item? Is there anyone in the room or online who wishes to speak in opposition to this item?
Good morning, Madam Hearing Officer. My name is Mark Bentley, 401 East Jackson Street, Tampa, 33602. I represent Stephen and Patrick Ray, the owners of the adjacent property, which is contiguous and located to the south. Also, they are the grantors of the easement. And before you run my time, this is a little more complicated than it appears at first blush, and I might need additional time, but just a couple of minutes if we get to that point.
The opposition has 15 minutes. Can you do it in that time?
No, I'm trying, and then I want to have my clients testify, and I've got some composite exhibits I want to walk you through.
All right, we'll see how much time is required, and then I'll grant the equal time to the applicant if that's necessary.
The applicant indicated what brought us here was a poor relationship between the parties, and that's not the case. What brought us here was misrepresentations by her family and her father to induce the county to allow for certification of a parcel split on the property that's subject to the easement. And also these fraudulent representations to the county as a consequence of the certification to obtain a single-family residence building permit, which at best is turned into a duplex or maybe a triplex. As recently as yesterday, we investigated that. I just want to note to clarify that if this variance were to be approved, a new parcel certification would have to be issued by Hillsborough County to replace the one that was issued in 2000, as that one would need to be revoked. And based on the information I'm going to give you in exhibits, this would be an impossibility, as there are at a minimum 3 units on the certified parcels, as the Hyder's certified parcel consists of an illegal duplex, maybe a triplex, And the RSC zoning district, which governs the subject property, only allows single-family conventional. We've got photos and information from the property appraiser, which characterizes the subject property as either a duplex or a triplex. So in the event you were going to grant a variance, it's not to two legal single-family homes zoned RSC 6. It would be to a legal, at best, duplex and a legal single-family residence zoned RSC 6. In the urban service area under the code, the maximum amount of units that are allowed to be served by insufficient, or excuse me, an access easement is 3. So you would have a 20-foot instead of 30-foot access easement serving 3 units, maybe 4. If it's 4, then they don't qualify. If the variance is denied, the 2001 parcel certification will be revoked and the lots will have to demolish their property. I have 5 appellate cases, 4 appellate cases, 1 from Florida Supreme Court, and stand for the proposition basically that if you obtain permits to induce a government to issue a permit based on misrepresentations of fact, that not only is the permit revoked, but the local government has the ability to cause for the construction to be removed. I want to talk about the impacts of the easement on our client and the basis for their objections. Number 1, doesn't allow sufficient access for life safety equipment, which they have witnessed and can testify to. That's in section 1, Exhibit 1, section 6.02.01B5 requires a 30-foot wide legally established easement. Here again, they only have 20 feet. They represented the county. They had 30 feet to get the certification, which I'll show you how they forged a document. Also, section 5.01.02B13, that's Exhibit 2. It says the easement shall provide sufficient ingress and egress for fire trucks, ambulances, police cars, and emergency vehicles. And that's the public policy or the basis for an intent for the 30 feet. I submit to you today the only testimony or evidence you're going to hear concerning access, whether it's sufficient or not, and there will be nothing to contradict this because we pulled down the file. It looked like life safety hadn't commented on this file, is going to be the testimony of our clients who've witnessed the inability of fire trucks to get back to the subject property. Another objection is they granted an easement for 1 house. Now it's encumbered by or used by 3 homes. And it's a non-exclusive easement, which our client still has the ability to use. So now you have additional traffic utilizing the easement that was never agreed to or contemplated. Note that there is land located to the north owned by a church that they could acquire or obtain an easement. And now Ms. Hyder is seeking an easement for 3 dwelling units. The evidence will show that the 20-foot easement has been reduced to 15 feet by the applicant, who has purportedly granted a 5-foot perpetual water line easement over the north 5 feet. This prohibits its use in paving and definitely prevents two-way traffic and life safety equipment from accessing the property. And I'll get to that exhibit. The evidence will show that Ms. Hyder's father, Richard Hyder, perpetrated fraud on the county to induce the county to allow for parcel certification. Misrepresentation number 1, they applied for a building permit for a single-family unit. Misrepresentation or parcel certification. Misrepresentation number 2, they misrepresented on their building permit application for the 8710 house owned by the Hyders for a single-family development, which became a duplex after 2003, maybe a triplex, which is not allowed, as I mentioned, RSC 6. The certified, or also the objection is the certified parcels and legals are to be recorded according to the county in both deeds. This clouds our client's title as well. If it says on the record that there's a 30-foot easement and there's only a 20-foot easement. Objection number 4, the overburdening of the easement, which I mentioned. The easement was granted to one lot and not 3 units, and our clients, the grantors, were never apprised of the parcel certification or conversion of a single-family home to a duplex. Note, if you grant the variance, you would be acting outside the scope of your authority with all due respect and granting legal access to an illegal use, a duplex in the single-family district. The history of deception and disqualifies the applicant from obtaining a variance. Ms. Lott's suggestion responding to the criteria. She's an innocent participant and says the former owner submitted paperwork to the county for parcel division and misstated the actual width of that easement. Those are her words, that there was a misstatement. That's interesting, as the former owner was her father, and Ms. Lott's been very involved in this property since the 90s per the documents I'll submit. Under Ms. Lott's illogical perspective, it's no different than saying the prior owner built an illegal carport who was my father, so I'm entitled to a variance as I didn't create it, as I wasn't an owner, but I'm the new one. You as an owner are obviously obligated to comply with the code, so you simply can't change ownerships to qualify for a variance. And it's also unique, therefore, that the two elements, and also unique, therefore, the two elements of the variance criteria she did not meet. It says the intent of the code is what happened wasn't the result of an illegal act, and the hardship cannot result from that illegal act. There's nothing unique about Ms. Lott's property or situation. Typical illegal easement and construction seeking mercy from the county at this point. Okay, here we go down to kind of the meat and potatoes. Exhibit number 3, this is the access easement you mentioned. You look on page 2, it simply says 20-foot ingress and egress, and it's a non-exclusive easement, so our clients still have the ability to use the property. Exhibit 4, October 2000, the county issued by mistake a parcel certification letter allowing the new lot and her dad to construct an illegal duplex per property appraiser. He misstated that there was a 30-foot perpetual easement to the property, when clearly, if you look at Exhibit 2, it's a 20-foot. Page 2, it's required to be recorded with the deed creating a cloud on our client's property. Now, if you look at Exhibit 5, what you can see here, this is an Autocad drawing, and here's a Hillsborough County stamp. You can see all the numbers are AutoCAD, and this is what Mr. Hyder submitted to the county to induce the county to issue the certification. The only number that's drawn in for this easement that goes from Sheldon Road to the west to the subject of their property, it says 30 feet. You can even tell by the scale, that would have been 1.5 times as wide, and it's handwritten in there, 30 feet. So what's going on today is this is like a cold case. The county, 21 years after it issued the certification to allow the lot split, cited the Hyders for violating that code section based on the misstated legal description and based on the misstated width of the easement. And that's the document that the county relied on. So it's clear fraud. Mr. Hyder provided the county with a site plan showing a 30-foot easement to induce the county to approve the certification. Exhibit 6 is 2003 building permit application. Here again, another fraud perpetrated on the county. It says for a residence, which is now a duplex, violating the code. Note that the county application says, and I'm paraphrasing, the permit is issued for lawful construction. In the last paragraph, and the permit says that the applicant is providing accurate information under penalty of perjury. This is an important point, is one of the reasons Ms. Hyder says she's entitled to receive a variance is because, quote, Hillsborough County did not completely review recorded easements. So she's pushing it back on the county. Can you imagine if the county had to analyze every legal description or easement that came into their office? They take information Okay, at face value, once an applicant attests to that the information is accurate, that they're providing under penalty of perjury, that's just what they do. They don't map every easement. So it was represented there were 30 feet. In reality, they're 20 feet. So 21 years later, the county caught up with them, and here we are. So if you receive a permit by mistake or fraud, it is void under Florida law ab initio, as if it never existed. Talk about the history, the probate order in 2009, Exhibit 7. You need to check this out. Easement was 20 feet. Now, unilaterally, the hiders have reduced that to 15 feet. It says, which is another cloud on the 20-foot easement. It says that there's a 5-foot perpetual easement, exclusive utility easement for installation, replacement, and repair of water lines across the north 5 feet of the client's property. So the 20 feet now went down to 15. It's an exclusive easement in that court order from probate. We don't know where that came from, but now they're down to 15. Look at Exhibit 8. In 2017, April Hyder conveys to De Jesus, the other applicant today, their property, and she receives consideration in the amount of $210,000. So between getting the $210,000 from De Jesus and renting out their property for several years, they've recovered their investment. There's no reason why that home cannot be demolished. It should be under Florida law. And I'll just kind of zip through these. Exhibit number 10, De Jesus. You see the property appraiser with the way they classify the property. It says it's a single family residential. If you look at Exhibit 9, first page, property appraiser characterizes 8710, which is the lot property, as multifamily residential, less than 2 units. Go to the second page from the property appraiser, and it actually says 2 units. Okay, we just pulled that down a couple days ago. Go to Exhibit 11, you'll see photos. There's at least 7 photos. It shows the 1-story building is 1 unit, and the 2-story building is 2 other units. That's a duplex. So they're based on the information we received, it's a triplex. Exhibit 12, this is online from like realtor.com, that type of thing, says it's multifamily property. So I'm requesting that the zoning department investigate this. And here again, with all due respect, Madam Hearing Officer, I don't think you're prepared or in a position to reasonably consider this variance as there's no life safety feedback from the county, and you don't know how many units are using the easement. Here again, under the code section we're dealing with, it's limited to 3 units to use an easement in the urban service district. So you could be granting a variance and looks like it appears to an illegal use not authorized by the RSC 6. So Ms. Hyder or Ms. Lott is not an innocent bystander, as I hope you can see by now. In June 2018, email to county, which is Exhibit 12, she states, my family has owned this property since 1993. Exhibit 13, February 2019, letter from her lawyer to my client confirms access easement for Ms. Lott's parents. She doesn't meet the criteria. Number 1, unique and singular. As a result of misrepresentations to the county, they don't have the 20 feet. But illegal acts don't qualify to make the situation meet the criteria. Number 2, deprivation of rights. They're not going to be deprived. They never had any rights, substantial interference. Number 3, they've overburdened the easement, additional traffic noise, etc. and a 3rd unit, so they're unlawfully using the easement. Number 4, it is not in harmony with the LDC for a number of reasons. Number 5, it's an illegal act. Number 6, there's no substantial justice. It'd be an injustice if they actually got the variance.
Mr. Bentley, how much more time do you need to finish up?
3 to 4 minutes,
All right.
including my client.
All right, I'm going to grant you 5 minutes.
Okay.
Okay, and I'll do the same for the applicant.
Okay, then I've given you case law. I don't know the number of the exhibit. There are 5 appellate cases. They generally stand for the proposition that approval based on, as a result of misrepresentation, is void ab initio and allows local government to request removal of improvements. And you can take a look at those. The bottom line is the certification of the parcel issued is based on misrepresentation. They're in violation. The building permit for 8710 issued was also based on misrepresentation on two fronts. Number one, they indicated it was for a single family. Number two, they indicated they had a 30-foot easement. Number three, the certification must now be revoked. Next, 8710 must be removed per case law. Also factor in that Ms. Lot has profited from the sale of the property to De Jesus, and they've received substantial rent over the years. You're not here as a court of equity trying to do what you think may be right and factor in the consequences of this applicant whose family has profited off of these misrepresentations to the county, and then pointing the finger at the county for not doing its job. You're here to hear the facts, testimony, and evidence and apply these criteria. And in this situation, you have a violator who was caught 1 years after the fact by the county and who clearly doesn't meet the criteria. So I think the right thing would be to deny this application. Now I want to call up one of my clients and he'll just take a minute or two. Guys, who's going to speak? Okay, state your name and address. And
Good afternoon. My name is Steve Ray, and I'm one of the owners at 6913 Sheldon Road, Tampa, Florida 33615.
Thank you. Go ahead.
So what I wanted to get on record and state, and which is a major concern of myself and my brother Pat, is back in early March. I guess apparently there was a 911 call, but when they showed up to the property, they didn't know exactly where it was coming from. They determined that it was coming from the property behind us, the Hiders, and the one Mrs. Lot owns. So they couldn't get their emergency vehicles down the easement road. There was a fire truck and an EMS vehicle. So they got their equipment out in their bags and they hoofed it down the 500-foot easement road. We just saw the emergency vehicles out there. I didn't know what was going on. So we both went out there to find out what was going on naturally. So by the time we got out there, they were coming back. I guess apparently the 911 call did not come from that property, but they were visibly like out of breath and they were like very disturbed that they couldn't get down there. So was I, for that matter. So, we talked to them for a minute and they didn't know where the 911 call came from. Then they left. So my major concern is that, emergency vehicles can't get down the property, and God forbid someone down there needs emergency care, a child, someone having a heart attack, emergency vehicle or emergency operators trying to get to these folks that are feet away, and say, for instance, someone dies, unfortunately. Of course, they're upset. So wondering why they can't get these vehicles down there. And I own Easement Road. How legitimate liability on my part, but it's a concern. And that's the major honest of this among everything I said. But that's my major concern, the fact that.
Mr. Gray, this happened? And so describing then wide, is that correct? And is wider than 20.
I guess I didn't ask them why they couldn't down there. They're the ones who said they couldn't get down there. These were potentially, I don't know. They didn't go down there. And I asked why they didn't go down. They said they couldn't get down. I didn't know that, but I'm just telling you what happened.
Thank you. Is that all you have? All right. Thank you. I have some questions for you.
Question-wise, you've observed it's either duplex or...
Mr. Make sure you're speaking in the microphone there.
Thank you. You've observed for years. Okay, you've been doctors yesterday, and you can see in the photos, and you took some of the photos, duplex or a tri.
To my knowledge, yeah, it's definitely The house, there's one dwelling, and on the south side, there's two sets of stairs, a lower unit and a unit. So, yeah, I mean, it's there.
And then, did you more than one family? Okay, any family? Okay, thank you.
Thank you.
Thank you.
Mr. Gray?
Yeah.
Okay. Mr. Bentley, first of all, words like misrepresentation and fraudulent, I don't take lightly, and I think you know that. I'm going to ask the county attorney to speak to some of the issues you raised, but I just want to ask you to clarify. Your clients own the property to the west, is that correct? Right on Sheldon Road?
They own the property directly contiguous to the south, and they're the grantors of the easement. They own the underlying fee of this easement. The property starts at Sheldon and goes east the entire length of the easement. And then this fraud and misrepresentation, the applicant themselves indicated in their application, they characterize it as a misstatement of the facts.
I don't need to address that. I just
Okay, no, I'm just letting you know.
Okay, thank you. Also, you said several times that the permit should be void under Florida law. You're talking, I guess, about the certified parcel split?
Yeah, the logic is there was an illegal split that resulted in what was supposed to be a single family home, which is now a duplex. Okay. So that's kind of the fruit of the misrepresentation.
Right. And that certified parcel split is not before me today, of course. The only thing before me today is 20-foot wide or 30-foot wide easement.
Yeah, but it's so tied together because it's an easement for an illegal parcel with an illegal home on it or duplex on it. That's all I'm trying to get to you.
I understand.
Yeah.
That's all I have.
Hey, thank you very much.
Thank you.
I really appreciate the extra time.
Thank you.
You're welcome.
I would like to ask Mr. Bentley, sign in with the clerk, please. All right, let's go to, are there any other, well, I guess that's it. We had proponents, we had opponents. All right. I'd like to ask the county attorney's office if you could please address an issue Mr. Bentley raised.
Madam Hearing Officer, I'm here. What specific issue would you like to address?
Is there anything that prevents the land use hearing officer from considering the variance just as it is, 20-foot wide or 30-foot wide? Mr. Bentley has alleged that because there are more dwelling units than there are supposed to be, or the certified parcel split might have been fraudulently obtained, that the hearing officer would be overstepping her boundaries to even consider the easement variance.
Well, as to the facts on the ground, I'll, in terms of what's being varied and what actually exists right now, Mr. Hisney can speak to some of that stuff. Obviously, there are no use variances. As far as the easement, I understand that there is essentially what amounts to 2 easements within the 20-foot space. Nothing that's reviewed or granted by the hearing officer can negatively affect the easement, as in, if a variance is granted, it would prevent, code enforcement from issuing citations for something that was placed into the setback area. However, the easements really exist in and of themselves. The violation of an easement or making it inoperable would, violate the easement, but that's not really the purpose of the hearing officer review. It's to, in this instance, to determine whether the 6 criteria are satisfied to approve a variance of the setback area. As far, and I don't want to go deeper into the other things that were alleged or, charged by Mr. Bentley if you don't have any questions on those. So I'll stop now just to see if you have anything else you want to, anything specific that you want to ask.
No, nothing else.
I'm sorry, for the record, I'm sorry, since I'm not on screen, for the record, this is Cameron Clark with the County Attorney's Office. Thank you.
Thank you, Mr. Clark. All right, the app, let's see, development services. Did development services have anything further?
Just a couple of quick comments. As referenced in our staff report, the easement that's crossing the Ray's property. If you want background information on that, you can get the report for PRS 19-1266, and I'll give you a detailed background on that.
What was that one again, please?
It's referenced in the staff report, but it's 19-1266.
Thank you.
Regards to Mr. Bentley's comment that the Land Development Code limits easements to access 3 dwellings, I will direct you to section 6.02.01.5, and the code actually limits easements to serve 3 lots, not dwelling lots. And then if with regards to the type of dwelling unit on the one lot, if you find that relevant, this information that's presented today in the photos is new to us, so I can't really address it, but I would point out that a single family home is permitted to have an attached accessory dwelling unit subject to the requirements in the code. Whether this structure is that situation or something else, I can't state, but a single family home with an attached accessory dwelling is not a duplex under the Land Development Code. And that's it, unless you have any question.
No, that's it. Thank you, Mr. Hisney. All right, we'll hear from the applicant. So please state your name for the record, and I granted an additional 5 minutes to the opposition. If you need it, you may take 10 minutes.
Okay. April Lott. First, I wanted to state how Mr. Bentley cannot seem to separate the fact that I was not the owner prior to my dad's death on November 15th of 2008. I was not responsible for the former owner. Was it my dad? Yes, it was my dad, but he can't seem to separate that. Secondly, my name is April Lott, not April Hyder, so he keeps addressing me that way. As far as the life safety is concerned, my family has owned this property since, I believe, 1995, I don't really know the exact date, but my parents did own this property, and my mother did pass away in the house, and there were ambulances, there were fire trucks.
Speaking to the microphone,
there were plenty of emergency vehicles that were able to come to the very back parcel. There are 2 single-family residents on this particular property, which is unique. The only access that we have to this property is via the current access easement.
2 single-family residences on which property, Ms. Lott?
Well, that's what we're here for, the 2 parcels. That is the only thing that's back there. It's bordered by their property, and it's bordered by a church on the other side, and there's a creek in the very back. And we do have a photograph of a fire truck coming down the driveway. They have a cell tower on their property that they lease, I guess, the land. I'm not privy to their finances. And I want to just make a statement that Mr. Bentley is not privy to my finances either, although he's stating that
Ms. Lott,
I have benefited, and he's saying that I made all this money. You know, I didn't know that he was privy to my personal finances.
Okay,
so they lease a piece of their land to a cell tower. So there are a lot of 911 calls that come to that cell tower that are not for, these properties. And just to make it clear, I'm not really sure what a fire truck, the difference between a fire truck being able to get down this driveway if there's 1 parcel or 2 parcels. The access is the same. So, he has a lot of assumptions, and he doesn't really have any facts. So that's really all I have to say.
Okay, thank you.
And by not granting this variance access, the 2 property owners, all of the property owners will not have access to their homes. Their children won't be able to sleep in their beds. They won't be able to get up and go to the bus stop. That's what the consequence of not granting this variance is. All right. Thank you.
Thank you, Ms. Lott. All right, that closes the hearing then on variance 21-0586. And I think we have 4 special use cases to hear. We're going to take a 15-minute break, and then we're going to come back and hear those 4 special use cases. Okay?
One.
All right, welcome back to the May 24, 2021 Land Use Hearing Master meeting. I'm Pamela Jo Hatley. I'm the Land Use Hearing Officer today. And we'll continue then with special use cases. Mr. Hisney?
Yes, the last case finished section G of the agenda, which takes us now to section H, which are special uses. First application is H1. This is application number 21-0454. The applicant is TSP Companies Incorporated, and they are requesting a 3 PS alcoholic beverage permit, which requires separation waivers. Staff report and recommendation will be presented by Steve Beachy following the applicant's presentation.
All right, we'll hear from the applicant first then. Is the applicant here?
Good afternoon. I'm online.
Okay.
Good afternoon, Madam Hearing Officer. My name is David Wright, President of TSP Companies. Our address is P.O. Box 1016, Tampa, Florida 33601, and I have been sworn. I'm presenting a request for a 3 PS alcoholic beverage permit to allow beer, wine, and liquor to be sold in sealed containers only for consumption off the permitted premises, package sales. The development currently has a 2 COP X alcoholic beverage permit that was approved under application number 19-0777. And if approved, the 3PS would replace the existing special use. The subject property is located on the west side of US Highway 301 and south of Cone Grove Road and is zoned planned development, last modified by major modification 2898 to permit a commercial development, including a liquor store. This special use application requires distance waivers to a community use, which is a daycare, and residentially zoned property, which I believe are adequately addressed in the Development Services staff report and the justifications that were required to be submitted with the application. We noticed the surrounding property owners and the required supplemental notifications for waivers, and I have not been contacted by anyone who opposes the request. The Development Services staff has found the request to be approvable. Therefore, I respectfully request your approval of this application. And this concludes my presentation. I am available for questions.
Thank you, Mr. Wright. All right. Development Services.
Good afternoon, Steve Beachy, Development Services. The pursuant to Land Development Code 61111, the request is for a distance separation waiver for a 3 PS alcoholic beverage for the sale of wine to be sold on site for package sales. The wet zone area will compromise a footprint of 11,620 square feet. Proposed wet zone is located as close to a residentially zoned property, requiring a 220-foot waiver to require 250-foot separation. The second waiver is the proposed wet zoning is located 130 feet from Stacy's Learning Center and Childcare, requiring a 370-foot waiver to the required 500-foot separation. With regard to staff findings, with the surveys that was submitted, the nearest residentially zoned property is utilized for stormwater purposes. The nearest residentially zoned properties that are developed with homes are located 160 feet to the west and 145 feet to the northwest, and there will be no direct access from the liquor store to the residentially developed properties. The normal route of travel between the uses will greatly exceed 250 feet. With regard to the child care center, it is located 130 feet to the northwest of the proposed wet zoning. However, the normal route of traffic travel between the two uses will exceed 400 feet. For the reasons discussed above, staff finds the proposed wet zoning does not pose significant adverse effects on the residentially zoned property or the child care center for which the separation waivers are requested. Staff finds the proposed 3 PS wet zoning approvable. Approval is based upon the revised wet zone survey submitted on April 12, 2021 for 11,620 square feet of area. That concludes my comments.
Thank you, Mr. Beachy. All right. Is there anyone here or online who wishes to speak in support of this item? All right. Is there anyone here or online who wishes to speak in opposition to this item? All right. Hearing none. Development Services, do you have anything further?
No, do not.
Okay. All right. Applicant, do you have anything further?
No, ma'am. Thank you.
All right. This closes the hearing then on special use 21-0454.
Our next case is item H2, special use application 21-0537. The applicant is American Investments LLC. They are requesting a 3 PS alcoholic beverage license, which requires separation waivers. Staff report and recommendation will be presented by Laura Marley following the applicant's presentation.
Yeah, pull the microphone down, would you please? Thank you. There you go.
Good afternoon. I'm here to represent my client at 10020 Cross Creek Boulevard, Tampa. He's requesting a 3 PS beer, wine, liquor off premises only.
Did you give us your name?
Oh, I'm sorry. Dixie Liberty.
All right, Miss Liberty, and your address?
13359 Ashbar Court, Riverview, Florida.
Thank you.
23579. The business is going to be a package store. He will be open 7 days a week, and that there are some waivers. The community established within 500 feet. We have a New Tampa Regional Library, distance is 404 feet away, asking for 96. Benito Middle School, distance 404, asking 96. Eber Baseball Park, distance is 435, asking for 65. The residential is behind to the north of the business. That is within 250 feet. The distance is 44 feet, asking for 206 feet. The walking distance is well over close to 1,000 feet. There's also establishments on 3 or more of the within 1,000 feet of the same kind. Let's see what else we have here. The libraries are across the street. They do not face, the package store does not face any part of across the street. That faces more towards the south. That's about all I have on that one. You got any questions?
Nope, I don't have any questions. Thank you. All right, Development Services.
Good afternoon, Laura Marley, Development Services. The request is for a distance separation waiver for a 3 PS alcohol beverage development permit for the sale of beer, wine, and liquor to be sold in sealed containers only for the consumption of the permitted premises only. According to the applicant, the proposed wet zoning area will consist of 1,496 square feet for a proposed liquor store. The proposed liquor store will be located in the Cross Creek Center at the northwest corner of Kinnan Street and Cross Creek Boulevard. The proposed 3 PS will replace an existing 4 COP RX wet zoning. The applicant has accurately depicted the separation waivers that she's asking for the community uses from residential and for the certain types of alcohol beverages. There have been no objections to the proposed wet zoning from neighborhooding residents or other tenants of the shopping center. The school district staff objects to the proposed wet zoning on the grounds that it does not meet separation requirements from Benito Middle School. Parks and Recreation staff does not object to the proposed wet zoning. Library Services does not object to the proposed wet zoning, and staff finds the request to be approvable based on the wet zone survey indicating a total of 1,496 square feet of floor space. That was received March 16th, 2021 with the following condition. Upon approval of the alcohol beverage permit SUAB 21-0537, the existing 4 COP RX alcohol beverage permit on the parcel SUAB permit 080145 shall be rescinded. Thank you.
Thank you, Ms. Marley. All right, is there anyone here or online who wishes to speak in support of this item? All right, is there anyone here or online who wishes to speak in opposition to this item? Don't see anyone. All right. Development Services, anything further?
No, ma'am.
No, ma'am.
And applicant, did you have anything further?
No, ma'am.
Okay. Then this closes the hearing on special use 21-0537.
Our next case is item H3.
I need you to come sign in with me, please.
Our next case is item H3, special use application 21-0597. The applicant is J Restaurant Group LLC. The request is for a 4 COP alcoholic beverage permit, which requires separation waivers. Tanya Chapella will present staff report and recommendation following the applicant's presentation.
All right, is the applicant here? Okay.
Hi,
Thank
Tennessee
you.
Liberty, 13359 Ashbar Court. Here on behalf of my client at 2810 East Barris Avenue, Lukes, Florida. He's requesting beer, wine, liquor on and off premises. It's a 4 COP. The building contains 2490 square feet. My client's going to be opening up a lounge in the vicinity in the plaza. We're asking for 3 waivers. There is a church to the west. It's 160 feet away, asking 340 feet. Also an RSC6 that is also on the church property for the residents. The second one is the residential is separated by a 6-foot fence, tree shrubs. It's 5 feet away, asking 245 feet. Walking distance is well over 1,000 feet. There are more than 3 of the same kind within the vicinity of 1,000 feet. Let's see, the plaza established commercial area that characterizes the presence of several restaurants in the area that serves alcohol. This is really a growing area.
Okay.
Questions?
What kind of establishment is this? Is it a restaurant or
It's
just a bar?
A bar.
Okay.
Yeah.
And the other establishments in the shopping center, are they?
There are 2 COP licenses for mostly beer and wine. Let's see, I have 2 COPX, 2 COPX, 2 COPX, and a 4 COP, and a 2 COP.
Okay.
So
right.
mainly they're beer and wine, except for the one with the 4 COP, and that's at the end of the plaza. It's like an Irish bar or something.
Yeah. I think they're all restaurants, aren't they?
Yes, ma'am.
Okay. Okay. Thank you.
All righty.
That's all I have. All right, development services.
Good afternoon, Tanya Chapela, Development Services. The request is for distance separation waivers for a proposed 4 COP alcoholic beverage permit to allow for the sale and consumption of beer, wine, and liquor on and off the permitted premises. The proposed wet zoning is requested for a restaurant at 2810 East Bears Avenue. The wet zone area will comprise a total footprint of 2,490 square feet, as shown on the revised wet zone survey received May 17, 2021. No outdoor area is being proposed. So for the Land Development Code, Section 61111, proposed 4 COP wet zonings must be located at least 500 feet from specified community uses and 250 feet from residentially zoned properties, and there can be no more than 3 existing wet zoning of certain types within 1,000 feet. Per the submitted survey, there is 1 community use within 500 feet of the proposed wet zoning and residentially zoned property within 250 feet. Additionally, there are 7 existing wet zonings of the specified types with 1,000 feet of the proposed wet zoning, all of which are located in the same shopping center as the proposed wet zoning. So the shopping center in which the proposed wet zoning is located is flanked on the west and north sides by an apartment complex on property zone PD and RMC 20, which the portion zone PD being adjacent to the shopping center. The applicant requests a 245-foot waiver to the required separation distance to allow a separation of 5 feet. Then the applicant requests a 340-foot waiver to the required separation distance from a Faith Life Church to allow a separation of 160 feet. The applicant requests a waiver to the maximum number of existing wet zonings within 1,000 feet. And as per my staff findings, the entrance to the proposed wet zone establishment is oriented away from the adjacent apartment complex, and the wet zoning is comprised of enclosed building space with no outdoor area. Additionally, the portion of the apartment complex that is nearest to the wet zoning is occupied by an office, a pool, and direct access between the wet zoning and the residential property is blocked by a fence, resulting in a normal route of travel between the 2 uses of more than 490 feet. The entrance to the proposed wet zone establishment is oriented away from the church to the west, and the 2 uses are separated by the apartment complex and a single-family home on property zone RSC6. Additionally, the shortest route of travel between the 2 uses is approximately 680 feet. The proposed wet zoning is located in a commercial center that is permitted the type of businesses which commonly serve and sell alcoholic beverage. There are currently 8 existing wet zonings within the shopping center, 7 of which are of the specified types relevant to the separation requirements for the proposed wet zoning. Staff recognize the proposed wet zoning will further increase the concentration of specified wet zonings within the commercial center, but finds that due to the relatively small size of the premises and the circumstances discussed above, it does not pose a significant increase in the cumulative impacts of those wet zonings on surrounding uses. For the reasons discussed, staff finds the proposed wet zoning approvable. Approvable is based upon the revised wet zone survey reflecting a total wet zone footprint of 2490 square feet total area and received May 17, 2021. This concludes my report. I'm available for any questions.
Thank you, Ms. Chapella. All right, is there anyone here or online who wishes to speak in support of this item? Don't see anyone. Is there anyone here or online who wishes to speak in opposition to this item? Don't hear anyone. Okay. Development Services, do you have anything further?
No, I do not.
All right. Applicant, nothing further. All right. Thank you. This closes the hearing on Special Use 21-0597.
And that brings us to the final case on today's agenda. It's item H4, Special Use Application 21-0604. The applicant is Tam Bob BB LLC. They're requesting a 2 COPR alcoholic beverage permit, which requires waivers. Staff report and recommendation will be presented by Tim Lampkin following the applicant's presentation.
All right, is the applicant here?
Yes.
Okay.
Good afternoon. Good afternoon, Madam Hearing Officer. My name is Amanda Hesson. I'm the authorized representative for Tambaugh BB LLC, which is the property owner. I am located at 119 South Monroe Street, Suite 202, Tallahassee, Florida, 32301. I am here on behalf of the property owner and the occupying tenant, leaseor, which is, or leasee, Bob Evans Restaurants LLC, doing business as Bob Evans Restaurant number 502. They are located at 16314 North Dale Mabry Highway, Tampa, Florida 33618. The special use with waivers required is an application for a 2 COPR permit for the sale of beer and wine for consumption on and off the premises only, in connection with the use of the restaurant. The restaurant has been an ongoing use at the property. They are a family style restaurant. At least 51% of the restaurant's total biannual sales are derived from the sale of food and non-alcoholic beverages. They are a bona fide restaurant and they offer a variety of prepared meals for dine-in and take out to customers, including a bakery and desserts, steak and seafood, soups and salads, burgers, sandwiches, etc., as well as non-alcoholic beverages. They would like to add the option for customers to be able to choose to purchase beer and wine alongside their family-style meals. The overall indoor alcoholic beverage sales area for the restaurant is 5,219 square feet. The distance separation requirement for a 2 COPR under the Hillsborough or the city of Hillsborough County ordinances is 500 feet from certain community uses and 150 feet from residentially zoned property. As indicated on the wet zone survey and special use site plan, there is one community use, which is Gaither High School, which is located within 68 feet of the restaurant. There are no other community uses within 500 feet of the property. And there are no residentially zoned properties within 150 feet of the subject property. Therefore, waivers are required to exempt the distance separation requirement from the Gaither High School community use. The proposed use will not negatively affect the community use of Gaither High School, given that the proposed use is the sale of beer and wine only. Liquor is not contemplated and liquor is not desired for this restaurant. They only want to sell beer and wine for consumption on and off the premises. Consumption off the premises would only be in connection with a takeout meal. The subject restaurant is actually located to the adjacent side of the parking lot for Gaither High School. So it is not located near the entrance or exit for Gaither High School. It is rather located near the parking lot and is a further distance away from the entrance or exit to the actual school building. Given the restaurant's proximity from the actual building, there should not be any new or unusual interference to the community use. And that is all.
All right, thank you. Thank you. All right, Development Services.
Hello? Can you see me? My computer's freezing on me, believe it or not. Yay. All right. Sorry about that. Per sections 61111, the request is for a distance separation for 2 COPR alcoholic beverage permit for the sale and consumption of beer and wine on and off the permitted premises in connection with a restaurant. At least 51% of the restaurant's total biannual sales shall be derived from the sale of food and non-alcoholic beverages. The property is located at 16314 North Del Mabry Highway. SUAB 0604 requires a distance waiver from the 500-foot distance requirement to certain community uses. Gaither High School is located 68 feet from the Bob Evans restaurant, and the applicant requests a 432-foot waiver to the required 500-foot separation from Gaither High School. Staff finds the following. LDC section 61111E3 provides for approval of separation waivers where there are special or unique circumstances where the alcoholic beverage use applied for does not have significant impacts on surrounding land uses in certain circumstances, negate the necessity for the specified distance requirements. The proposed wet zoning is approximately 345 feet from the nearest building on the high school property. Additionally, the proposed wet zoning is separated from the high school by an existing chain link fence and a vegetated buffer. Therefore, the normal route of travel is approximately 750 feet from the restaurant as the automobile or pedestrian navigates. The proposed wet zoning is requested. It's an established restaurant, and the 2 COPR category is restricted to restaurant use. The school district staff objects to the proposed wet zonings on the ground that it does not meet separation requirements from Gaither High School. No other review agencies had any comments. For the reasons discussed above, staff finds the proposed wet zoning does not pose significant impacts on the surrounding uses. Staff finds the proposed 2 COPR wet zoning approvable, and this is based upon the revised wet zone survey reflecting a total wet zone footprint of 5,219 square feet received on May the 7th, 2021. And that does conclude staff's presentation.
Thank you. All right. All right, is there anyone present or online who wishes to speak in support of this item? I don't hear anyone. Is there anyone here or online who wishes to speak in opposition to this item? All right, do not hear anyone. Development Services, anything further?
Nothing further.
All right, applicant, did you have anything further?
Nothing further. Thank you.
All right, thank you. All right, this closes the hearing then on Special Use 21-0604. And that ends the land use hearing meeting today.